explain how this establishes duty. They instead argue a duty exists because it was foreseeable. They argue it was foreseeable because of two prior complaints that they made regarding AZZ Roulette. The two prior complaints referenced in the TCEQ report clearly state that no violations resulted. So plaintiff's own evidence of foreseeability actually undercuts their argument. But plaintiffs do not in any way explain how AZZ Inc. breached its duty as the license holder for the facility. Plaintiffs also rely on the tape lift sample results that are mentioned in that TCEQ report attached as Exhibit 1 to the response. But the TCEQ later backtracked that, saying that the tests were uncertain and they were unable to rely on them. Therefore, there's no elements established for negligence. For plaintiff's trespass to personality claim, defendants challenged all three elements. Plaintiff's response does not specifically point to evidence establishing any of the elements. For the first two elements, plaintiffs attempt to meet their burden by incorporating the arguments from their negligence section of their response. Plaintiffs only specifically cite to a single page of the TCEQ report for the second and third elements. There is nothing on that page of the TCEQ report that could possibly be described as evidence of the second and third elements of their trespass to personality claim. Therefore, plaintiffs have not produced evidence sufficient for any element of their trespass personality claim, and it must fail. And then with regard to vicarious liability, plaintiffs have alleged that AZZ Inc. is vicariously liable under a theory of respondeat superior. AZZ is not vicariously liable for the negligence and trespass to personality claim merely by virtue of being a parent company of AZZ Roulette. Without evidence of control or something beyond that, that would essentially defeat the purpose of organizing separate entities between huge corporations. And plaintiffs do not plead that AZZ Inc. maintained control over or that AZZ Roulette was an agent of AZZ Inc., and they should not be allowed to do so for the first time in their response. And then lastly, regarding piercing or plaintiff's claim of piercing defendant's corporate veil, plaintiffs have repeated the same claim that they were denied depositions. This is categorically false. We have now addressed this on 3 separate occasions. Yet plaintiffs knowingly repeat the verifiably false statement to the court in what would appear to be a deliberate effort to mislead the court by misrepresenting defendant's conduct here. Plaintiff's counsel should be expected to answer why he's knowingly continues to make this false claim despite irrefutable proof to the contrary. But regardless, plaintiff's only evidence is the TCEQ report identifying AZZ. Indisputably, that is not evidence of AZZ being the alter ego of AZZ Roulette, or that the corporate fiction was used to perpetuate a fraud on plaintiffs. Therefore, plaintiffs have failed to point to any evidence to support either element necessary to pierce defendant's corporate veil. For these reasons, defendants respectfully request that the court affirm its prior ruling and grant defendant's motion for summary judgment. Thank you, Your Honor.
Response?
May I be brief, Your Honor?
You may.
On page 3 of my response, I incorporate by reference the summary judgment that was already heard by the court, where the court determined that AZZ Roulette, where we narrowed down to the 2 issues. For the purposes of why there's 196 pages is because I didn't want to have to deal with the whole, you didn't attach the entire thing. I could have just attached the first 10 pages of the TCEQ report and then item 14. But the other stuff was attached because it is referenced in the original and optional completeness. I did point to the fact that AZZ is the named authority, and opposing counsel has said this multiple times, that somehow there is some magic report somewhere which rescinds all, in their mind, somehow takes AZZ out of the equation. But they never point to how or where this supposedly occurs. I mean, if nothing else, Your Honor, we are left to a weight of the evidence argument. Is AZZ Inspector 1 correct? Or my apologies, is the TCEQ Inspector number 1 correct? Or is the TCEQ Inspector number 2? That's a genuine question of material fact, Your Honor, and it goes to the weight of the evidence, and it is not something subject to a summary judgment. So we have merely asserted, in order to save the time and energy here, that AZZ is a named defendant. And as a named defendant, to make all of these other allegations that, well, they're not the right defendant, Your Honor, we've said they're not the right defendant, and they can't prove we're the right defendant. So therefore, we have to assume that we're right, that we're improperly named, and summary judgment should automatically issue, and that is not the standard. The court has already determined that there is sufficient evidence presented to take the AZZ defendants forward on 2 claims. And that's all I'm asking, Your Honor, that AZZ remain in the case until these 2 claims are resolved, because there is a question as to whether or not it was AZZ Rowlett or AZZ Inc. And they are a named defendant, Your Honor. That has not been addressed or dealt with in any way, whether I do it under respondeat superior, whether they claim that there's a piercing of the corporate veil, they're still a named defendant, Your Honor. And I think that that satisfies this. The court has already ruled on the entirety of the motion. We just carry forward that AZZ remains in as to the same thing AZZ Rowlett does. Thank you, Your Honor.
All right. And have you guys sent me a binder or not?
No, sir, I did not send one.
Can you guys send me a binder that includes both sides briefing on this, as well as any relevant case law and everything, basically, because I know there's a reconsideration, all that kind of stuff, just that includes everything in that. Mr. Delaney, if you can put that together with Mr. Reeves' help, just try to get that to me by the end of the week. I'll make a decision at some point, and I know we have a trial setting in June, so we'll try to get that in July, at the beginning of July. We'll try to get a decision sometime in June, but can you get that to me by the end of the week?
Yes, Your Honor, no problem.
All right. Thank
Yes,
you, guys. You have a great rest of your day, okay?
Thank
you,
you,
sir.
you as well, Your Honor.
Thank you. All right, are both sides here on Harriet Nicholson versus Nation Star Mortgage?
Hi, Your Honor. Here for defendant, Matt Durham here.
Is anyone here for the other side?